Hello and welcome to Module 7, quite a long one this one, and I'm talking about information and consultation. Regulation 13 of TUPE requires the transferor, the outgoing employer, and the transferee, the incoming employer, to inform and consult with their affected employees about any transfer before it happens. Now, this process stops employees being kept in the dark about a transfer and makes sure they can object if they want to. An employer has to always provide employees with information about a transfer, but a consultation exercise is only required if the employer plans to take any measures, that's the word, measures, in connection with the transfer which will affect employees. So in this module, we're going to discuss which employees are affected by the transfer, who are the appropriate representatives, what information you need to provide, including when should it be given, how does consultation work, the special circumstances defence, and sixth, potential sanctions for failing to inform and consult. Transferors and transferees have to inform and consult in relation to their own affected employees. Now, this means employees who are affected by the transfer or any measures, that's the key word, measures taken in relation to it. It doesn't just mean the employees who are in the organised grouping of employees or resources which transfers. It covers three categories. Affected employees are the transferor's employees who may or indeed will transfer. So the transferor's employees who are affected because they might transfer. Then there's the transferor's old employer, the transferor's employees who aren't transferring, but whose jobs might still be affected by the transfer. And finally, the transferee's employees, so the incoming, the new employer, the transferee's employees whose jobs are affected by the transfer, or indeed affected by the incoming employees. So, for example, an employee who isn't going to transfer might still be affected by the transfer if they do some work for the part of the business that's being sold. And an employee who's got a job application pending in a business or part of a business that's transferring will also potentially be affected by any transfer. Now, the rules say that the transferor and the transferee must inform and consult with representatives of their own employees, not each other's. So a trade union recognised by the transferor has no right to information or consultation from the transferee, the new employer, before the transfer. In practice, though, there's almost always going to be voluntary communication between a transferee and the transferring employees. And we'll look at this later when we talk about consultation on measures. If the employer recognises a trade union, they should inform and consult with union representatives. If there's no trade union, then the employer has to consult employee representatives, either existing representatives or new ones elected for the task. Now, existing employee representatives should only be used if their remit already covers this sort of responsibility. Representatives from a works council which deals with financial matters would probably be suitable. Representatives elected to organise the office party definitely would not be. If trade unions only represent some groups of employees, but not all employees, employers might find themselves dealing with both trade unions and employee representatives to make sure all employees are covered off. Meetings can be joined to avoid duplication. Employers have to allow representatives access to the employees and to any other facilities they might need to conduct proper consultation with employees and with management. This might include meeting rooms or access to phones and email. Now, there are detailed rules about electing employee representatives, which are contained in Regulation 14 of TUPE. I'm summarising them. Massive oversimplification and summary for this course. Go and look at Regulation 14 if you're actually doing this, or take legal advice. But in summary, you as the employer have to make sure the process is fair and that elected representatives cover all employee groups. All representatives have to be affected employees themselves, so you can't have someone as a representative who's not affected by the transfer personally, and they've got to be elected before consultation starts. Now, this means that an employer might have to break the news about a TUPE transfer earlier than they would otherwise like. The rules are relaxed for small businesses with fewer than 10 employees. Regulation 13A of TUPE allows small employers to inform and consult directly with affected employees if there are no existing representatives. That takes some of the administrative burden off the employer without removing protection for employees. What information does the employer need to provide about the transfer? Remember, we're dealing here with information, not consultation. Consultation I will cover in a second. Well, the employer's got to provide basic information about the transfer, the fact it's happening, when it will happen, and the reasons for it. They've also got to provide information about the transfer's, quote, legal, economic, and social implications. Unhelpfully, that phrase is used in TUPE, but isn't defined in TUPE. For transferor's employees, the old employer, it should include enough information about the proposed transferee, i.e. the new employer, to allow employees to assess the impact of the transfer. So what does it really mean? Well, legal implications include whether TUPE applies to the transfer and the effect of TUPE on an employee's legal rights. So it includes any proposed changes to terms and conditions or major plans like a relocation or redundancy. Economic implications, well, that includes the effect the transfer will have on employees' pay and benefits. Of course, it shouldn't have any. Or on the amount of work they might be given if they're hourly paid rather than salaried. The transferor, old employer, outgoing employer, should give enough information to allow its employees to assess whether the transferee is financially stable. Social implications might include any proposed changes to working patterns or shifts. If the transferee intends to relocate the business, moving to a new house or a school would be a social implication for employees and their families. Employers should provide information on house prices and local schools in the new area. Information must also be provided about the number of agency workers employed, where they're working in the business and the type of work they're doing. Information should be in writing, and copies of this should be given to each of the employee representatives. It should be hand-delivered or sent by post to the address specified by the representatives. Employees are usually most concerned about potential changes which the transfer will bring about. Measures is a wide term. It includes any action or step or arrangement taken in connection with the transfer. It could include changes to things like pay, working hours, or union recognition. It could also include a relocation or redundancies. The transferor has to give its own affected employees information about any changes it plans to make. But the transferor must also inform employees about any measures that they envisage the transferee will take after the transfer. So communication between buyer and seller here is key to making sure that the transferee provides that information in good time for the transferor, old employer, to pass it on to the employees before the transfer. Now, in relation to measures, nil responses are required. So if no measures are intended, employers have to tell representatives just that. The transferor must also tell transferring employees if the transferee doesn't intend to make any changes after the transfer. When should the information be given? Well, employers have to make sure that relevant information is given to representatives long enough before the transfer to allow meaningful consultation to take place. There's no set time scale. It's not like collective redundancy where you've got to allow at least 30 or 45 days for consultation before the redundancies take effect. There's no set time scale, so the time period depends on the extent of the measures that are planned. Remember, no planned changes means no consultation is needed. The more measures are intended, the more time is needed between providing the relevant information and the transfer. Circumstances are relevant too. If the employer gives the information a few weeks before the transfer, but 2 weeks of that is a shutdown period when no one can be contacted, that's unlikely to be enough time. And that's because there won't be enough time left for consultation before the transfer. The duty to consult only arises if either the transferor or the transferee plan to make any changes in relation to their own employees. Consultation has to be meaningful. It should aim to reach an agreement, but with all types of consultation, we see this with redundancy consultation as well, agreement isn't always possible. If alternative suggestions are made by representatives, the employer should acknowledge them, and if the employer rejects suggestions, representatives should be told why. Now, the consultation requirement is limited to an employer's own employees about their own measures. So that means the transferee, the new employer, doesn't have to consult directly with transferring employees about changes it intends to make after the transfer. The transferee's only obligation, weirdly, is to provide that information to the transferor to pass on to employees. Nor does the transferor have to consult with the transferring employees about the transferee's proposed measures, which does kind of make sense, because how can that business engage in meaningful consultation about this business's planned changes? Now, this gap in TUPE-related communication arises because the TUPE rules relate to an employer informing and consulting its own employees about the transfer before it takes place. The transferring employees aren't employed by the transferee until after the transfer. So consultation between the transferring employees and the transferee about any proposed changes don't start until after the transfer. Any changes the transferee makes after the transfer will therefore need not only comply with TUPE rules, so regarding contractual changes after a transfer, I think is the next module, but also with normal employment law rules. This gap in communication can cause significant worry for employees, and the new relationship between the transferee and the transferring employees can start off on a very bad footing. For this reason, many sensible transferees will voluntarily open lines of communication with transferring employees before the transfer takes place. Voluntary consultation about proposed changes might help to get future employees on board with plans at an early stage. It's voluntary, though, not a legal requirement, and the process should be carefully supervised by the transferor, the outgoing business, to make sure that nothing's done by the transferee which might open the transferor up to liability. For example, if a transferee says it's going to impose significant contractual changes after the transfer, that could be an anticipatory breach of contract which allows an employee to resign immediately and claim constructive dismissal against the transferor. Voluntary consultation can also start before the transfer if the proposed changes involve mass redundancies, 20 or more. Some transferees have historically chosen to do this voluntarily, even though pre-transfer consultation doesn't count towards its legal collective consultation obligations. But the law on this was recently changed, I say recently, 6 years ago, by the Collective Redundancies and Transfer of Undertakings Protection of Employment Amendment Regulations 2014. Whoa, what a mouthful. And that allows pre-transfer consultation to count towards collective consultation requirements. This is great news for transferees who want to act quickly following the transfer. An employer might have a defence if sued for failing to inform and consult if it can show that there were special circumstances which made it not reasonably practicable to inform and consult, and it had done its best in the circumstances to comply. It's not an easy win. I talk about this a lot more in my course on redundancy at gettingredundancyright.com. It's not an easy win, but occasionally the defence will succeed. In a case called Unison and Somerset Council, the employer didn't consult about a proposed measure which arose shortly before the transfer. And a special circumstances defence was allowed where events moved rapidly, a deadline was imminent, and there was a chance the whole deal might collapse. And in that case, the Employment Appeal Tribunal noted there'd been exemplary and significant consultation in all other respects. But just doing nothing won't wash. A failure to inform and consult won't affect the transfer itself. The remedy is a claim for compensation. Affected employees can bring a claim if the employer has failed in relation to the election of employee representatives. The employee representatives themselves or the relevant trade union can also bring a claim for failure to inform and consult with them. And if a claim wins, and a tribunal thinks that there's been a failure to properly inform and consult and the special circumstances defence isn't made out, a tribunal can award appropriate compensation. Now that means the amount the tribunal thinks is fair, bearing in mind the severity of the employer's failure to comply with its duty. And there's a maximum payout of 13 weeks gross pay for each affected employee. Remember, that's not limited to the employees who were actually transferred. It can include a lot of others still at the transferor's company and at the transferee's company who weren't actually the subject of the transfer themselves. There's no cap on gross pay, no weekly cap, so the sums involved can be quite large. Now, the general approach is that the maximum should be awarded, 13 weeks pay should be awarded if there's been no consultation at all, unless there are circumstances which justify a lesser award. Technical breaches might attract no compensation, although I've never known a nil compensation case, whereas a deliberate decision to ignore the rules will probably get the full 13 weeks. So ignore the information and consultation rules at your peril.